There we go. Welcome, everyone. Oh, don't mute yourself, Gordon. We won't be able to unmute you. There we go. Welcome, everyone. This is the Employer Handbook Zoom office hour. Didn't figure that out already. My name is Eric Meyer. I am the publisher of the Employer Handbook at theemployerhandbook.com. I'm also a lawyer, an employment lawyer at FisherBroyles, the first and largest distributed law firm, cloud-based law firm in the world. And I am joined today by one of my fantastic partners. I am sitting up here in Cherry Hill, New Jersey, but I've got a Southern gentleman here with me. Gordon, how you doing today, buddy?
Very well, thank you. Appreciate you having me.
Tell everyone a little bit about yourself.
So I am Eric's partner at FisherBroyles. I have been practicing law for longer than I can remember. And like Eric, I focus primarily on representing companies in labor and employment matters. And although I do reside in the South, I am a native New Yorker. I'm sure you can tell from my voice, I do not originate from the South. So that's kind of my little intro. And certainly I look forward to providing you some guidance and wisdom today as Eric steers us through this webinar.
Excellent. Well, thanks for being here, Gordon. And apropos of what Gordon just said, you know, we're going to give some advice, but it's not really legal advice. He's a lawyer. I'm a lawyer. I'm not sure how it works, but what we're doing today is not legal advice. Just remember that. We're not creating any attorney-client privilege. We are not giving any sort of specific legal advice. And our clients pay for that. And I see some clients on here, which is a bit of a cop-out, but that's okay. You guys can still ask questions in the chat. But what we're doing still is not providing actual legal advice. If you want legal advice, go contact your lawyer. Pay for it. He or she will say it depends a lot. That might be a bit confusing because we're going to say that too. But we'll do our best to answer your hypothetical questions that you're asking for a friend. Anyway, we've got so much to cover today. First thing we wanted to do is talk a little bit. I'm going to update you. I'm going to start. It's my pod. It's my webinar. I'm going to start. We're going to talk a little bit about the Biden stimulus and where it stands. So last night, one of the House committees was pouring through the Biden stimulus. I read, and you may have seen at some point that there was supposed to be a minimum wage hike in the Biden stimulus. I don't know that it's going to make it through. Looks like there was some kind of parliamentary procedural snafu with the minimum wage hike. Gordon, the minimum wage was going to be what? It's going to step up over 5 years, I think it was?
Yeah, so by 2025, the proposal was to increase it to $15 an hour under the Raise the Wage Act. This was a reintroduction. This bill has been brought up in several sessions of Congress. Not a surprise, certainly, Eric, because you've got 29 states and DC that have minimum wages that are above the current $7.25 per hour. And then you have a few states that already passed legislation recently to raise their state minimum wage to $15 an hour, that being California, Massachusetts, and Florida. So it's kind of a natural progression in my view. But yes, and I saw the Republicans in the Senate are using some vehicle to block it. They won't allow it to be included in the appropriations bill. So I agree with you. Right now, it doesn't seem to have enough traction.
Yeah. And that was one of President Biden's big initiatives, was to raise the minimum wage. But it's not to say it won't happen. And if it does happen, like Gordon said, it's going to be a step up over time. We're not going from 7.25 to 15 overnight. It would happen over probably 5 years. But here's what I can tell you about what was in the latest version of the House bill that I saw. Families First Coronavirus Response Act. They're talking about extending the credits that employers can take through the end of September. So let's rewind a little bit. Remember, Families First Coronavirus Response Act, paid sick leave, paid family leave for coronavirus-related reasons. That sunset on December 31st, 2020. If you were a qualifying employer, fewer than 500 employees, you could, but did not have to, continue to provide FFCRA leave and get the tax credits through March 31, 2021. The current draft of the bill would extend that March 31, 2021 deadline through September. Now, at some point, there was talk of basically making it mandatory again for employers of less than 500, but giving them the same tax credit, but then also bringing in employers with over 500 employees and having them provide FFCRA leave with no corresponding tax credit. That is not in the bill. So it's, again, looks like it's going to be voluntary through September. There's going to be some a pump in the tax credit. It goes from 10,000 to 12,000. So, we'll see what the final version looks like. But hey, that's voluntary, get a tax credit. Why not? One other thing on the stimulus, I want to close the loop, getting back to minimum wage. There is another proposal from Mitt Romney and Tom Cotton in the Senate. It's called the Higher Wages for American Workers Act. And that would increase the federal minimum wage to $10, automatically raising it every 2 years to match the rate of inflation. But the catch with that, not really a catch, there's another part to it, and that is that it would require employers to use E-Verify to ensure that businesses can't hire illegal immigrants. I would suggest to you, given that we have essentially Democratic control in the Senate, that is not going to become a law. But I just wanted to put it out there that does exist. There is some other non-Biden stimulus related legislation going on that we wanted to talk about. A question came up during the last Zoom session, office hour, about the PRO Act. And I said I would get to it, and we didn't get to it. So let's get to it now. Gordon, you want to talk a little bit about the PRO Act, which is pending in, I guess, both the House and the Senate, right?
Yeah. So Democrats on February 4th introduced what is acronym of PRO Act, is Protecting the Right to Organize Act of 2021. It is, again, a reintroduction of a bill that was passed by the House last March. And the 2021 version has most of what the prior bill had, but it is purporting to dramatically amend the National Labor Relations Act. And so if you want, Eric, I can kind of go through some of the highlights.
Sure.
Okay, so one of the more salient issues is that it would restore joint employer status, i.e. the test that's used to determine joint employer under the pre-Browning-Ferris decision. Browning-Ferris basically held that you needed direct and indirect control in order to be considered a joint employer. And then the current standard is that if you don't, even if you don't, you have to exercise the control. Sorry, if you don't exercise that control, you would not be considered a joint employer. But this would roll that back to, if you had the right to do so, you would essentially be a joint employer, even if you didn't exercise it in that regard. Another significant and controversial component is this ABC test that comes out of the state of California. Now, the ABC test is to determine who's an independent contractor. And so it incorporates this test into the National Labor Relations Act. And essentially, unless someone's free from control and direction in performance of the service they're performing, they are not considered an independent contractor. And it has to be outside of usual course of the business, meaning if anything that's integral with this that they're doing that's part of the business, they couldn't qualify as a contractor. And then they have to be an independent trade, occupation, profession. Like your lawyer is clearly not one of your employees when you hire outside counsel. So it would be a very stringent test. And there's a couple other things that are probably important to most of you all. One being, it's going to make a more stringent standard for what is considered a supervisor, because supervisors are not part of who can collectively bargain or who have rights under the unfair labor practice provisions. They wouldn't be part of the rank and file. And then there is a whole push to give unions more speed and simplicity in being able to conduct elections. It's very anti-employer in that regard, including mail balloting, which is not permitted right now. And then there's a preemption of the right to work states, which would mean it would mandate that all employees would have to pay union dues and it'd have to be part of the whole collective bargaining and so forth. So those are the, but to me, I'm saving the best for last. The whole barring collective actions or class action waivers in arbitration agreements. If you have followed along, the Supreme Court in Epic Systems held not too long ago that you can create an arbitration agreement with an individual employee that would allow for the right to waive class or collective action waiver status, which means that person would have to independently arbitrate any wage and hour claim they would have. This would completely throw that out and mandate that no one can bar class actions, no one can waive it, and it obviously therefore would also not be arbitrable. So it's a game changer because current board law doesn't prohibit someone who is disciplined. It's not an unfair labor practice charge for an employer to, if they refuse to sign an arbitration agreement, they can be disciplined. That would change that. So it's a very, I mean, it's consistent with the fact that Biden fired the top two attorneys at the LRB, the general counsel and associate general counsel, and replaced him with Orr, who is a Democrat and who is more pro-union. So I think that's, if it passes, it's more challenging for employers in the organized labor arena to have to deal with these issues.
And here's the deal. It has no chance of passing. However, it is a bit of a wish list. It's not a bit of a wish list. I mean, it's a wish list. But what we're seeing, and Gordon alluded to it, is through rulemaking and through decision making, both the National Labor Relations Board and the Department of Labor under the Biden administration can chip away at, let's say, the joint employer test that was supposedly going to become a rule under the Trump administration's Department of Labor. There was this test established for who would be joint employers. That's being pulled back, okay? Gordon alluded to independent contractor versus employee and a pivot towards the ABC test in the National Labor Relations Board context, in the traditional labor context. We're seeing that too now in the Department of Labor context. The Department of Labor has now pumped the brakes on a rule which would have codified who is an independent contractor. And as Gordon alluded to, it would come down to, under the Trump regime, control would be would be one of the big factors, and another big factor would be the ability to make profit or lose on the business transaction. So a traditional hourly employee has no ability to, there's no profit or loss there. They just get paid for each hour they work. If you're an independent contractor and you underprice the job, you're going to take a loss. We're going to get away from that test, it looks like, and maybe pivot into what we saw in California, Jersey, the ABC test, which makes it more likely than not that individuals would be employees rather than independent contractors. So, again, PRO Act, not too much in there to make it all the way through, but there are bits and pieces from the PRO Act, whether you have a unionized workforce or not, that could impact your workplace. Should we talk a little bit about the Equality Act briefly, Gordon? What do you think?
Sure, why not?
Fill them in.
So
latest update on the Equality Act. The Equality Act is the law that would make it unlawful to discriminate against individuals in the workplace and in other settings based on their sexual orientation or gender identity. That passed the House last night by a vote of 224 to 206. It now heads over to the Senate, where it is certain to be swallowed up in a lot of talk before we vote. There's gonna be a lot of talking about this, and the issue with the Equality Act, the critics' issue with the Equality Act is not that we don't want to, not that we want to mistreat people because of their sexual orientation or gender identity, but the fact that the Equality Act specifically says in the act that if you have some sort of defense to discrimination based on the Religious Freedom Restoration Act, basically a religious belief that, supersedes treating someone fairly based on their LGBT status, the Equality Act says you can't do that anymore. So the Supreme Court last year in Bostock versus Clayton County said that Title VII of the Civil Rights Act of 1964, because of sex, the prohibition of discrimination because of sex includes sexual orientation, and transgender status. But the court left open whether there could be a religious exception to that. The Equality Act would swallow that up. So that's going to be the holdup. That's why there's going to be a filibuster. And ultimately, I assume, Gordon, would you agree, some sort of compromise that comes through? I mean, I think we're going to get something passed, but a compromise?
Yeah, I think in a minimum, part of the intent of the bill too is to take the narrow category of gender identity and sexual orientation being because of sex only, which is, how they're getting it through Title VII, and expanding it to be outside of just sex alone. I think the EEOC probably even has authority to promulgate regulations that would address that. So I agree. There's probably going to be some component of that that'll make it through.
And meanwhile, many states, not all, many already have laws on the books that prohibit discrimination in the workplace based on sexual orientation, gender identity, transgender status, the whole, the like. Many localities have it as well. I practice law in Philadelphia, which is one of the most progressive cities in terms of employment laws. We've had that for a while. So just because the feds don't pass this and make a new statute, whether it's the Equality Act or not, we still have Bostock, which is the law of the land. We still have state laws. We still have local laws. Like Gordon said, the EEOC is going to continue to enforce Title VII as protecting against discrimination based on sexual orientation, gender identity. Most states will do the same. So it would be nice to have the Equality Act to further cement no discrimination, but we're going to have to work through those religious issues, and that's not something I want to spend too much time on today, because I know it's a bit of a touchy subject. There is one other piece of legislation, I wanted to talk about that's recently pending, and that's OSHA related. That is the Accurate Workplace Injury and Illness Record Restoration Act, which in a nutshell would clarify that OSHA's 6-month statute of limitations will be told if there is a continuing violation of the act that lasts longer than 6 months. This is really nerdy lawyer stuff. But for you folks, it directs OSHA to clarify that its record-keeping rule, there's a continuing obligation for employers to make and maintain accurate injury and illness records. So I don't think it would change a whole lot, but it is out there, and it's more of a clarifying statute than anything else. But it's still in its early stages, and far be it for me to say whether it will pass or not. Gordon, should we talk a little bit about Department of Labor and what's going on there? You alluded to it earlier, but should we put a little bit more meat on the bones?
We should do that.
Yeah. Do you want to pivot back into independent contractor and employee and ABC tests and all that stuff?
I can, sure. So the Department of Labor prior to the Biden administration taking office, had put out a proposed regulation that was going to revise and more favorably, in my opinion, address and kind of counter this ABC test that I sort of described earlier through a public comment period, et cetera, through the normal process to make it a rule. However, this was withdrawn and frozen essentially because some of the independent contractor status was in a group of opinion letters that were issued before Biden took office, right at the end of Trump's administration. Basically, the Department of Labor came out and said these were issued prematurely because they're based on rules that have not gone into effect, and so that it's not possible to enforce. And then those were supposed to take effect in March, including a tipped employee rule. And so when Biden, literally the first day he was in office, came in, he said that we're going to create a moratorium or a freeze on the proposed and pending regulations to give what is going to be his new appointees opportunity to review the pending rules. So those have been frozen, but there's still a push to eliminate this ABC test because it is so difficult to deem somebody an independent contractor. It just greatly expands the employee classification, and it creates obviously a dynamic. If you've got somebody who you're considering an independent contractor and you've misclassified them and they should have been considered an employee, you've got liquidated damages, attorney's fees, other potential exposure as an employer for that misclassification. So we'll see what happens.
Go ahead.
No, I was gonna say we'll see what happens. Right now, those are kind of on ice. It's just, but there's been so much controversy over California and the ABC test, including whether or not it's retroactive, because there's a whole Uber and Lyft have been fighting it for a long time as well. That it's gotten into the federal arena, and I think it's not a dead subject, but as you said, Eric, I don't think there's enough ability to run this through.
Yeah, this shift though towards the ABC test and hitting the brakes hard on the rule that the Department of Labor proposed to codify who is an independent contractor. And, as I talked about earlier, control the ability to make profit or lose money. This does not bode well for gig economy. So if you are in the gig economy, this is a strong smoke signal that your workers, if the Biden Department of Labor has its way, will be treated as employees and not independent contractors. If you have gig economy, if you have more, folks that are more traditional, stereotypical independent contractors, if under the ABC test they are actually employees, the issue, as Gordon alluded to, liquidated damages, wages. If these folks are working under 40 hours a week, you're probably okay, even if you've misclassified them, at least from a wage and hour standpoint. You might have tax issues. But if these folks are working more than 40 hours in a work week and you're not paying them a salary because they're an independent contractor, but all of a sudden they're employees, that's where the Fair Labor Standards Act issues really arise, because then you're getting into overtime. They're probably making minimum wage as it is, enough to cover minimum wage, but it's when they work more than 40 hours in a work week, which creates the real problem for businesses if folks are misclassified as independent contractors. And especially if you have a lot of these folks, then all of a sudden you're getting into the class action status. One other thing, before I talk a little, we shift back to joint employer. I want to talk a little bit more about that, is tipped workers. And Gordon mentioned that earlier. So the Department of Labor had proposed a rule which would clarify what employers that have traditionally tipped workers can do with them. So if you run a restaurant, for example, under the proposed Department of Labor rule, under the Trump administration, front of the house workers could tip pool with folks who are in the back of the house, not your supervisors or managers or things like that, but your cooks, your dishwashers. They could participate in a tip pool. With respect to the tip credit, right? So tip credit, you pay your servers, $2.13 an hour, and then as long as they make enough in tips to bridge the gap from that lower minimum wage up to $7.25 an hour, the employer could get a credit for that. What the Department of Labor said is that there used to be this 80-20 rule, where someone who's tipped would have to spend at least 80% of their time doing traditionally tipped work, and then 20% or less of their time doing non-tipped work. Think like wrapping the silverware, or bussing tables, or making the plates look pretty and stuff. Or, if you don't have an expo, things like that. So the Trump Department of Labor wanted to get rid of the 80-20 rule. So maybe it was more like 75-25, and you could still get a tip credit, or 70-30. I think that's not going to happen. I think we're going to see more. We're going to see that 80-20 rule. 19 comments. That's it. 19 comments came in during the comment period. Not all against the Department of Labor's proposed rule, but that was enough. Plus President Biden saying pump the brakes, to put a hold on this new tip rule, tip worker rule. And, we'll see how it comes out, but the progress that was made during the last term has been stunted. Gordon, anything more on joint employer in the Department of Labor in a traditional wage and hour context you think folks need to hear about now?
Well, I think the key is that if anyone is either a staffing firm or a PEO, or uses the services of those type of outsourced contingent workforce relationships, you should expect that there is going to be a more liberal interpretation of what constitutes a joint employer. It could be a sub and parent, or like a general contractor and a bunch of subs at a construction site arrangement. But I think Browning Ferris is still something that's going to come back in a way that plaintiffs' lawyers are going to use it to bring back in other employers and try to get another pocket, but to make an argument, for instance, that if you're a small employer and you only have 10 employees, but your purported joint employer has, 50 plus, well, then they can bring in all the employment laws that only pertain to employers that are of that greater size than the small employer.
FMLA.
Yeah, for instance, FMLA, or it might be they're not subject to the ADEA because they only have 10 instead of 20. But to that end, it's going to be, I think, a more liberal, broad interpretation in some capacity, whether it's done through rule, whether it's done through opinion letter, whether it's codified. You're going to find this happening in some manner, I believe, and even the courts, because now you've got Biden appointing vacancies, and they're going to be more liberal judges. So, is it going to happen immediately? No, but this is on his list of items that were part of his platform when he was campaigning, and so I think he's going to keep it as a priority item. It's just, if he's not going to get the PRO Act passed, I wonder how he's going to approach it from there.
Gordon, you mentioned PEOs. For folks who have, what is PEO? Folks, for folks who do know what PEOs are, we're talking to one of the PEO experts in the country here. Tell everyone a little bit about PEOs and outsourced HR and
Sure.
how that works.
Okay, great. So PEO stands for Professional Employer Organization. And so in theory, PEOs contract with companies, typically a small business, to outsource certain employer functions that every company has to perform. So it's payroll, it's HR, it's risk management, safety, benefits, et cetera. And so the concept is that in 40 plus states, a PEO is considered a co-employer of employees that it contracts with through its client company. And co-employment is not the same thing as joint employment because it's not a joint and several liability for all actions. What a PEO does is it takes certain employer functions and retains responsibility for those. Some are reserved by the client, some are shared responsibilities. So it's a different model than a joint employer. But a PEO, depending on the actions they take, can be a joint employer to the extent it controlled a circumstance that gave rise to, say, a discrimination claim. You know, if it said you have to fire this employee, the client of the PEO said okay, and then they get sued for it, someone could argue they were a joint employer in that context. But generally, it's considered co-employment, and like I said, it's codified in 40 plus states, and it's a way for small business to get a better suite of benefits typically. You know, because they're pooling all of the employees from all the client work. We call it worksite employers or work sites, and you aggregate them, and now you have like buying power for thousands of employees to get a great health plan, for instance, or stable workers' comp, or other benefits that come up. So, I mean, that's essentially the concept.
What are some of the HR compliance pros and cons of using, whether it's a PEO or outsourced HR?
So it's like anything else. You have to know who you're getting into business with. You're partnering, and you are basically relying on a PEO to provide the HR support. Although a good PEO isn't going to make decisions; it's going to make recommendations, and then leave it to the client to make the ultimate determination. But you know, it can be, like I said, a tool for employee retention by offering a better benefit suite. They can help with compliance, certainly, you know, but it's not a law firm, and they can't give legal advice. And, you know, in our multi-state, you know, more global universe, and particularly with people being remote these days, a lot of folks have, you know, a multi-state operation where one person living at home is like taking New York, New Jersey, Connecticut, the tri-state area. It could be a New York-based company, but they can have an employee living in Connecticut and an employee living in New Jersey. And now you need to know if that's where they're working, you know, how the laws work, but you also need somebody that can handle and deal with all the compliance that comes up. So in a way, a PEO could be a partner for some of that. But again, there's a line because it's not a law firm. And it's like you're hiring more sophisticated HR people, I suppose. And that's why it's called a professional employer. They're supposed to be experts in the business of running a business, right? It doesn't matter whether you sell widgets or you provide a service. Fundamentally, every company has to comply with wage and hour laws and hiring and reporting and, you know, anything that deals with labor. And that's what they step in and help with. So with the right partner, it can be a value-added service that you're gaining. And it's a springboard too for making sure you don't make unwise employment decisions that can come back to cost you a bunch of money.
Good to me. Folks, let's do a little bit of a reset here. About 12:30. I'm Eric. That's Gordon. Thanks for attending. This is the Employer Handbook Office Zoom Office Hour. We are talking about, what did we talk about? We talked about changes in the Department of Labor that are coming up. We just talked about PEOs. We've talked about some pending legislation, and we want to get to your questions too. So if you have them, please put them in down there, the chat. Use the chat feature down there. It's like the middle of your screen. Use that. You don't have to send, you can send the question to everyone. You can send the question to just me. Doesn't matter. We'll try and answer as many as we can because we're going to get to the Q&A pretty soon. I always feel like we don't quite get to everything, but maybe we'll start a little earlier today on the Q&A. A pro tip, if you send me your questions in advance, we're more likely to get to your questions. And I have a bunch of them. So I think we'll move to some Q&A for now. And remember, folks, we're not giving legal advice here. We're just, we're just giving practical tips. to questions that are hypothetical. Assume you're asking for a friend, and we're not creating any attorney-client privilege. And if you have anything specific, go call your employment lawyer, go pay for the legal advice. Don't try and get free non-legal advice on a Zoom office hour. That's crazy, okay? Talking about outsourcing and PEOs, someone asked me, this is a pretty broad question, so we can't answer it all, but what are some legal issues involved with employing remote workers, and especially remote workers out of state? So I mean, I'll lead off with that. And the first thing that comes to my mind is Fair Labor Standards Act and just wage and hour laws generally. I know we've talked about this. I've talked about this on the blog before, and I know we've talked about this in some of the Zoom office hours, but it's worth repeating, is making sure that your remote workers in whatever state they're working are at least getting the minimum wage if they're non-exempt, making sure they're getting paid overtime the right way. And one of the ways to do that is making sure that you have good time tracking mechanisms in place. So I just updated a handbook for a client, and one of the first places I made a beeline for in the handbook is how is our time tracking policy looking, especially in light of COVID and most everyone working remotely? Do we have a good mechanism in place to capture all of that time that employees, non-exempt especially, are working remotely, right? Do these employees are they being guided by their managers as to what hours they should be working? Or should they be emailing at 8 o'clock at night? Or not, right? If it's one email here, one email there, not a big deal. There's a de minimis exception to the Fair Labor Standards Act where a minute or two here and there is not going to add up. But otherwise, that time can continue to accumulate. And if it puts someone over 40 hours in a work week, now we're talking about overtime. And it might not just be overtime at $7.25 an hour if someone's getting paid minimum wage. It's overtime at the very least at the minimum wage of whatever the state sets it. And then if you're paying someone more than that, obviously it's based off of their higher regular rate of pay. And are you reminding employees that they shouldn't be working overtime without explicit direction or permission, authorization from a supervisor? So that's one of the areas that I focus on is Fair Labor Standards Act with remote workers working out of state. Gordon, what are some of the other issues that you're thinking about when you're dealing with out of state remote workers?
So issues such as workers' comp. Somebody can get injured at home, but in a lot of states, even if the employer is located in a different state, the injury occurs out of state. The person has the election to pursue their workers' comp claim in another state, and if there's a chance that the employer's not insured there, for instance, because they didn't have a workforce there until COVID hit. Another couple of concerns is somebody working out of their house, transmitting, confidential, proprietary, sensitive information, and the security of how they're doing so, like if they're tapping into the company's resources or their databases and so forth. There's a lack of control on the employer's part when somebody's using their personal computer at their home on their own internet. That can create, intellectual property and other concerns. And then you have other issues of, the accountability of the workers, the ability to perform the job. In other words, they have all the tools and resources, or does the employer have to buy them equipment? Because obviously the person has to be able to perform. And then you have tricky stuff like if the person wants paid time off, like this was really a FICRA issue that's no longer an issue at the moment, but it could pop up again if they reinstate it, which is, interim work versus leave. Some school districts still aren't fully back in person. And do I deduct time to the person devoting for personal matters like caring for a child? How do you know the comings and goings? So it's not just the timekeeping, but it's also the accountability of applying the proper leave and knowing what that would constitute. And that's a difficult thing to manage because there's nobody there to supervise the person. So I mean, those are the kind of things. Mhm.
Someone in the comments made a similar point, Gordon, remote workers in paid leave states. So the nightmare of dealing with unpaid FMLA versus paid family leave in a particular state or jurisdiction. So like New York,
Right.
I think Massachusetts now has paid leave. Connecticut, I believe. I don't practice these states, and I could be wrong about some of this stuff. I know New York. So that's a nightmarish issue for companies with employees that work.
Well, and there's another one, Eric, that's becoming more important, which is restrictive covenant agreements. Mm-hmm. So not only are non-competes under fire right now, that's another Biden initiative, particularly for lower paid wage earners. But you may have had employees sign your standard agreement, which was when they were working at your headquarters. Again, I'll use the tri-state area. They were working at your headquarters in Manhattan, but now the employees at home in New Jersey, and you're not applying the same law, and there's a chance that now your agreement is unenforceable.
That's a good point. I don't want to overstep here. I think what most employers do is they purport to apply the law of the state where headquarters is. And if you have people working remotely, well, the law of headquarters still applies. And there's usually a sufficient nexus between the law of headquarters and the interest in having one law apply to everyone rather than 25 different laws if you have people in 25 different states. But if you have a business in, let's say, Pennsylvania, where headquarters is, but you have a remote worker in California, and that worker who has signed a non-compete, which says that Pennsylvania law is going to apply, but they still work in California, where non-competes are unlawful, and they leave your company and go to a competitor right across the street in California, good luck trying to enforce that non-compete with Pennsylvania law in California against the California employee. So you never know what a judge is going to do, but I think in that scenario, you're fighting an uphill battle. So that's a great point with non-competes. And I agree with you. I think the trend is towards limiting and in some places outright banning non-competes. I mean, DC is the latest one. District of Columbia has banned non-competes. Many jurisdictions are at the very least looking to ban non-competes against low-wage workers. I don't think anyone's really trying to ban non-competes against, let's say, someone who sells their business, who stays on in an official role. You don't want that person who had all the secret sauce, who sells their business, opening up a new business across the street and competing. I don't think anything's ever going to touch that. But in the traditional employer-employee context, the trend is to limit non-competes, to a certain extent, non-solicitations, and to a much lesser extent, if at all, non-disclosure of trade secrets and confidential information. That proprietary stuff's pretty important. Let's see, we had a bunch of other questions. Here's a good question that came in. Especially in light of having remote workers, COVID, how can a business satisfy its legal obligations by maintaining a workplace free from harassment? So even remote workers can be harassed. How do we maintain a workplace free from harassment while fostering an environment where employees feel safe speaking up? And let me put a little nuance on that. I remember this email because the person who wrote to me said, employees and managers want to feel like they have a safe space to talk to one another, to sort through issues without necessarily making it a big production that involves HR. So is it possible, Gordon, to have a safe space where an employee and a supervisor can work out a harassment issue without involving HR? Can that be done?
It can be done. I mean, obviously the immediate best practice that a company should employ is training and education. And that's twofold. It's employees having knowledge and understanding of what constitutes inappropriate conduct, harassment, et cetera, and then having the means to avail themselves of some resource internally. So how do you report it? What will happen if I report it? How is it going to be investigated? And in a lot of cases, unless that supervisor is the alleged harasser, certainly it can be resolved through reporting to your direct supervisor. Obviously, in more egregious cases or where it involves the supervisor, the policy has to allow for flexibility, and you'd have to go outside of that, and inevitably it ends up in HR at a larger organization. But I don't think the dynamic changes because harassment, that is because of remote, because harassment can emanate in so many ways, including through non-physical contact. You could be texted, you could be subject to video, you could be subject to words, none of which require you to be in my presence, for you to be a harasser. So, I mean, I think it's just a continued obligation as a good corporate citizen for companies to step up and make sure that these policies are in the forefront and everybody's clear on what's expected and have a zero tolerance policy for things that are just flat out inappropriate.
Yeah, the risk, and I think what this was getting at was that confidant relationship. I mean, the risk of having the confidant is that if the manager can't work out the issue and resolve the issue for the employee, right? Let me take a step back. Once the manager knows, the company is deemed to know. That's how the law looks at. That's how Title VII looks at it, for example. So in a confidant situation, if the manager can sort through the issue with the employee and the employee is satisfied with the result, great, no harm, no foul. But if the manager can't do it or isn't equipped to do it, then if the harassment happens again, the employer will be deprived of an important defense. That is,
right,
under Farragher-Ellerth, which is these two Supreme Court cases, the employer has to provide an avenue, a mechanism for employees to complain, right? So you have a handbook with an anti-harassment policy and a complaint procedure. That's part one, in training, that kind of stuff. But part two is then taking steps that are reasonably designed to end the complaint of behavior. And if you can't, if in a confidant relationship, if the manager doesn't take what an objective person would view as reasonable steps to end the complaint of behavior, then you're deprived of that important defense. So personally, I would shy away from the confidant relationship. Hopefully, the workplace generally, the culture is such that from the top all the way down, we take anti-harassment very seriously. We take diversity seriously. We take inclusion, equality seriously, and that becomes part of the fabric of the business, part of the fabric of the workforce, so that when issues do arise, people feel comfortable not just confiding in one person, but going above and beyond that, even if there needs to be an investigation. But it's a tough one. That is a tough one. I can give you a lawyerly answer, but I understand the practical implications of having a confidant.
Well, and just to kind of follow up on your point. So I don't think in most cases it's wise to create a sort of colleague, friend type of dynamic between a supervisor and a subordinate, because it does blur the line. And as you said, if that supervisor handles it inappropriately, it's imputed liability on the employer potentially, because they're a member of management, and if they don't handle it properly or they don't report it otherwise. So I think those are things that should be handled carefully. It's the same reason why a lot of companies have a nepotism policy, because you don't want to erode the authority in the manner in which things are handled because of the relationships.
Great point. We were just talking a few minutes ago, Gordon, about independent contractor and employee. And someone asked me if an independent contractor signs a contract, an independent contractor agreement with the business, does the length of the contract weigh one way or another? Does that does a longer contract make it more likely to be an independent contractor relationship? Should it be a shorter contract? What do you think?
So it's going to be one of many factors in my view. I mean, I'll say this, there are statutes that say it must be a permanent and not temporary basis, for instance. So the delineation in some states, like Ohio, has like a 1-year threshold on what's considered permanent. But the danger is the flip side, which is the longer somebody is doing what I consider same or similar type work as an in-house W-2 employee, but the delineation is you're paying them a gross amount and they're not eligible for benefits. You get into what happened back in the late 90s with Microsoft, which is they become what we call permatemps, or they become essentially discriminated against because they're not offered the same similar benefits as a similar situated individual that's treated as an employee. So it's kind of a balance, but it's not going to be dispositive in of itself.
You made two great points there that I want to emphasize here. One is it could depend on the state in which the business relationship is formed. So there is no federal law at this point that governs, yes, the Fair Labor Standards Act, but not explicitly. It's more through case law. But more the states may govern who is an independent contractor and who is an employee. That's one. Two, it doesn't necessarily matter what the contract says. I mean, I could write independent contractor agreement, and I could put a little paragraph in there that says the two sides agree that this is an independent contractor relationship, not an employment relationship. But guess what? If you control the individual, you tell them when to work, where to work, they can't subcontract, they can't hire assistants, you give them the tools, you tell them how to do the job, they have no independent discretion, no opportunity for profit or loss. I don't care what's in the piece of paper that you guys have signed. That's an employee. So the document that's signed is meaningful, but it's not dispositive. That's an important point. Another question that came up. Well, this is a bit of a touchy one. How involved should businesses get in police-related matters between coworkers? So, for example, you have a coworker who stalks or threatens another coworker outside of the workplace. How involved should the business be in policing that? That's a terrible pun, but yeah. What do you think?
Well, that's an ongoing debate because generally speaking, employers have circumstances that come up frequently where your question is, where is our purview with respect to what employees do on their own time? And this comes up with marijuana laws where it's recreational permitted in states. It comes up where persons are engaging in political activity or social causes, things that are not directly work related, but can an employer still discipline someone because, for instance, they showed up at the Capitol and engaged in that the siege on the Capitol building. It's the same thing. To what extent is it relevant to the employer? Is it work related? Do you get involved with law enforcement? I mean, obviously, if law enforcement are turning to an employer for quote evidence unquote or for statements, if there's some sort of need to maintain an alibi or for clarification of what was going on, because if something occurred on their property or during the work hours involving, say, employees or invitees, I mean, there's an inevitable need to be involved, but I don't think there's any bright line test we could ever create, and I think the circumstances are going to be fact specific and dictate. But that's something I wrestle with. Is I don't know where the line is ever drawn on where it's a private matter versus because if somebody's a victim of domestic abuse at home and they come to work and they're not, there are statutes in certain states like California, they might have some protections, or employer might have a duty. It just depends on I think on kind of what the scenario is.
Yeah, I think that's a good. It depends. That's a good one. A couple other questions that came in. We always get questions about vaccines. And someone asked, what's the latest on mandating COVID-19 vaccines, incentivizing COVID-19 vaccines? Nothing new, other than the wellness regulations that the EEOC had put out there are toast. They're done. So it's a bit of the Wild West. I mean, you can mandate COVID-19 vaccinations subject to the duty to accommodate under Title VII and the ADA. At least the EEOC says that. Your mileage may vary based on different states in which you conduct business. Incentivizing vaccines, that's where we get into a much murkier area. Because at one point the EEOC said, well, you can give someone a water bottle or you can give them a low value gift card.
Right.
But beyond that, I think we can generally agree that you can give people, a couple hours paid time off to go get vaccinated. I know New York is considering legislation to require that paid leave to get vaccinated. Could you give someone paid time off the next day to recover from any side effects? Sure. I don't see any problem with that. But can you give someone a round trip airfare to Fiji in order to get vaccinated? Probably a problem. That may be a problem. What about this? Is there ever a situation, Gordon, you can think of where it's okay for an employer to reveal to a customer that an employee has or has not been vaccinated? So I'm thinking like behavioral health. We have someone who goes into someone else's home and treats, let's say, a child in the child's home. Can you think of a situation where it would be okay for the employer to reveal to the child's family, yes, this therapist has been vaccinated or hasn't been vaccinated? I think that's a problem.
So I think conventional wisdom would be you only would provide that information based on business necessity. Start with that. Of course, that the EEOC has come out and said a vaccination is not akin to a medical exam. So it wouldn't violate HIPAA, for instance, or wouldn't violate the ADA to require the vaccination. Now, the separate question you're asking is, divulging the fact that whether somebody did or did not receive the vaccination to an outside party.
Yeah.
And I can see it in the context of if your employees are required to be on site at somebody else's facility, like your client, and you'd have to provide proof that they were vaccinated as part of that company's requirement of whoever gets invited on premises. So that's an example. I could also understand it in terms of for an invitee, from an OSHA perspective, or for a workers' comp perspective, you don't want anybody claiming that they were subject to unsafe work conditions because someone was not vaccinated or the employer wasn't taking proper protocols and therefore they were exposed to COVID. Because there's a lot of litigation, even though there's a lot of states that are making it immunity laws to protect businesses. It's not ironclad yet. It's not 100%. So, I guess those are the type of scenarios I can think of where it would be reasonable and business related, but just sort of as a matter of fact, like I wouldn't publish on your website, hey, Eric and Gordon got vaccinated, but Bob and Tony didn't. No, I wouldn't do that.
Right. We've got about a minute left. There are a bunch more questions I know we're not going to be able to get to, but I do want to get to one more. And then we'll wrap it up. And thanks for everyone for hanging in there. We appreciate it. We're getting to the top of the hour. Last question. And this is definitely one of those, your mileage will vary. I'm going to say that out front. Someone asked, can a company ever withhold pay from an employee that is commission-based pay only? So maybe you have a situation where you have the employee broke an office computer and you want to offset, take some money out of that person's paycheck, and it happens to be commission pay. Your mileage is definitely going to vary based on the state and how the state defines wages. But in the states in which I practice law, commissions are generally considered wages. So there are certain things you can deduct from a paycheck. You can deduct FICA, you can deduct for medical and health benefits. If you're a union, you can deduct certain union dues and things like that. But when you make other sorts of deductions, you might get yourself into trouble. So it's going to depend upon the state, but I'd be very cautious. I would consult outside counsel before you make anything other than the standard deductions from an employee's paycheck, commission, or other. And I'm going to end it on that. And I want to thank everyone for attending. I want to thank Gordon Berger. Thank you so much. This was great. The hour flew by. Anything you want to plug?
If you haven't subscribed to the employer handbook, it's and you aren't a regular attendee of these terrific webinars, you ought to do so. I mean, I have my own, and I have my own e-news list. If you have Eric's contact, you're welcome to. He'll pass on to me. I'd be happy to add you all.
Yeah, and if you go to FisherBroyles, FisherBroyles.com, and search for Gordon Berger, you'll find him there. You can search for him. You see the spelling of his name on LinkedIn. Connect with him. He's great. He doesn't bite. He's a great connection on LinkedIn. He shares some good updates there too. So thanks everyone for coming out. Appreciate you. Appreciate your time. Everyone, stay safe, stay healthy, and have a wonderful weekend. Bye, everyone.